Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? Food establishments are committed to serving all customers fairly, including offering reasonable accommodations for individuals with disabilities. On this episode of We Get Work, we explore how restaurants and other eateries can address common accessibility issues, such as accommodating service animals, providing accessible parking, and charging customers surcharges for requesting dairy-free milk alternatives. Our hosts today are Joe DePalma, principal in Jackson Lewis's White Plains office, and Jennifer Rusi, principal and office litigation manager in the firm's Nashville office. Both are members of the firm's Disability Access, Litigation, and Compliance Group. Jen and Joe, the question on everyone's mind today is, what are common types of disability-based claims and inquiries that affect restaurant operators? And how does that impact my business?
Hey everyone, thank you for joining us on today's podcast. I am Joe DePalma. I'm an equity partner here in the White Plains office of Jackson Lewis in New York. And with me is Jennifer Rusi down in Nashville, who's an equity partner down there. Today we are going to be chatting with you about some ADA public accommodation issues that we've been seeing in restaurants and food establishments across the country. And we thought it'd be a good opportunity to kind of highlight some of the recent cases we've been seeing that Jen and I have been working on together, actually. And the first one I think makes a lot of sense for us to talk about are a slew of cases happening across the country. Jen and I are working on California right now against coffee shops. And what it really is, and Jen, I'll let you jump in, but it's plaintiffs alleging to be lactose intolerant.
Or have milk allergies.
Which
we have learned are different things.
And we'll get into that. But essentially what they're saying is that because of these conditions, the coffee shops are violating Title III of the ADA by charging surcharges on dairy alternative milks. So if someone comes in and says, hey, I want almond milk or coconut milk, and there's a 95-cent surcharge on that milk, that's discriminatory because a person with lactose intolerance or a milk allergy has to pay more money for a coffee with a milk in it than someone who's ordering a regular milk. So that's the premise of the case. And Jim, what do you think?
And it's interesting because you use the word surcharge, which is what a normal term that we would all use, but it actually has a legal definition, which was one of the ways that we actually got the case dismissed originally that we had filed, against our client. Of course, the plaintiffs have gotten leave to amend, but that's where it stands right now. The plaintiffs are arguing that they don't have a like experience to other consumers who do not have a disability because they have to pay more money for the same experience or good, and it was really interesting, I think, from a legal standpoint, because this was a totally new argument, something that we really got to research and argue sort of out of the blue. One of the main cases that the plaintiffs focused on was a case out of the Northern District of California against a restaurant where there was the plaintiff in that case was a celiac, couldn't have gluten at all. And they had a separate gluten-free menu that they would direct anyone who had a celiac disease to. And these things were the same meals, they just lacked gluten. And in some cases it was a menu where it was like green beans that doesn't have gluten anyway. And everything on the menu was more expensive. And so we argued in our case that that's not the same thing. It's not analogous because in the cases that we're dealing with in these coffee shops, every single person who orders a drink made with almond milk or soy milk, oat milk, everyone pays the additional charge. It is not only for somebody with a disability. It is an ingredient-based price increase, not a disability-based price increase, which was the issue there in the matter. Another thing we argued in our case was that somebody who is lactose intolerant is not disabled. The court agreed with that. And based on what was alleged, the experiences that the plaintiffs in our case had, and essentially they just said they have a stomach ache if they consume dairy milk, as opposed to, if somebody with a peanut allergy, you could have an anaphylactic reaction, and something like that would be considered a disability. But just this intolerance to a single ingredient really doesn't rise to the level of a disability.
Yeah, I mean, I think you raise a good point, because the first time, just like even not reading it as a lawyer necessarily, but you read the complaint and it's, okay, this person is saying that they're having an intolerance to dairy and they have to pay extra money to have almond milk or something like this. The first thing I think is, you don't have to add milk to coffee, right? You don't even have to do that.
I don't. I take it black.
I do too. And any person who wants to get almond milk put in their coffee or coconut milk, they're going to pay whatever the cost is for that, irrespective of disability status. And then the other thing I thought about is, if you're a coffee shop, do you just have to, assuming that the plaintiff's theory is correct and that they can't be charged more money for a milk alternative? What do you do if you're working behind the counter at the coffee store? If someone just comes to you and says, hey, I have lactose intolerance, you can't charge me extra for almond milk. Like, are you supposed to just not charge them for almond milk just because they say that? And that would create another host of issues that I don't even know how you'd be able to resolve it. And I think the practical, if I'm a coffee shop owner and the law becomes, we can't charge extra money for products that are costing us more money to procure, I'll probably do one of two things. I'll stop getting those alternative milks because it's too costly, or I'll just increase my prices across the board, that instead of it being $5 for a cup of coffee and we'll charge you an extra 90 cents if you wanted an alternative milk, now it's just $6 for a cup of coffee and you could have any milk choice you want, right? I think that's really the practical effect. And then one of the other interesting things I thought about this case is one of the forms of relief that they were looking for. And I think in the initial complaint, Jen, you can correct me if I'm wrong, there was no injunctive relief necessarily they were seeking, but they were looking for a disgorgement of the profits. And can you explain to us, like, what did that mean?
Yeah, they had a claim for unjust enrichment and restitution. And so they wanted the coffee shops to, disgorge all these money that they had gained by, charging people for the non-dairy alternatives, which this was also not clear how you would figure out, like, which people we got them from unjustly who were disabled versus, just somebody who likes the taste of oat milk. But they wanted all of that money to be paid to the plaintiffs. And that was the one claim that we actually got completely dismissed without leave to amend regarding that claim. So the court really didn't like that argument and said, no, you don't get to get a second bite of the apple on that one, but you can potentially come back, draft your complaint so that, if you give us some more detail about the impact of dairy milk on, your body, maybe we'll look at it and see if maybe it's a disability. And then also, another argument about the charges. But I really don't think, particularly with the charge, because it's not a surcharge, because it is applied across the board to every person who wants a non-dairy alternative. And, like you said, the impact would be, you're just going to wind up with too many questions, or we're not going to offer them at all, or we're just going to increase the price of everything.
Right. And I guess one thing I'm thinking about, something you said earlier at the outset, a restaurant, is it required to offer their food to be gluten-free, right? There's right. No legal requirement that you have to provide gluten-free menu. Was it found unlawful that the gluten-free menu was more money than the regular menu?
Because it was considered to be a surcharge that was only for the disabled, because typically that was a situation where they thought there's no other reason to be ordering off this menu, and only people who said, hey, I'm celiac, I need gluten-free, they were directed to this menu.
So it wasn't a menu that was readily available at the table. It was only upon request.
Right. And they charged more money for it. And that was the downfall there.
So hypothetically, had the menu just been sitting on the table and a person who doesn't have celiac disease or doesn't have gluten intolerance, whatever, says, I just prefer to eat gluten-free because I think it's healthier, and I'll pay an extra $3 or $4 for my meal because it's gluten-free. I think that's more analogous to what we're saying in the coffee shop case, right? So that's an important distinction between the two matters. I think like one of the main takeaways from a case like this one, and this isn't too dissimilar to what we saw a couple of years ago with the Braille gift cards. There is a plaintiff's bar that are actively looking for creative ways to file hundreds or thousands of lawsuits across the country. And this is just a really good example as to if you're a place of public accommodation, a coffee shop, a restaurant, and you're offering a good or a service or a product to the public, there are people out there who are trying to figure out how that might violate the law. The Braille gift card cases, for those of you who don't know, I think Starbucks was the first company that actually introduced gift cards in Braille. So when you think about a gift card, it's just like a piece of plastic, like your credit card. And if you were visually impaired, you wouldn't know what card you were holding. You'd be holding any card in the world. And Starbucks put Braille on them. So a person with a visual impairment who knew how to read Braille could identify in their wallet, this is my Starbucks gift card. And I don't think there was really much more information on it other than Starbucks. And then we got a slew of cases where if you have gift cards, you also need to make them available in Braille. Our firm handled many of those cases. They were all dismissed, ultimately appealed, but never really went anywhere. But again, that's just another example of how these plaintiffs' firms are trying to come up with ways to file lawsuits and extract settlements along the way.
And interesting in both the Braille gift card cases and in this case, it came down to goods. The ADA requires that you have equal access to the places of public accommodation and access to the goods and services. And everyone has equal access. You can't go in there and say, no, we aren't serving you because you are blind or visually impaired, or no, we aren't giving you a latte because you have a milk allergy or a lactose intolerance. Whatever you charge for the goods, you can charge. The ADA doesn't regulate goods. It only regulates the access, to have equal access to the goods and services. And so that was also a big turning point in both of those cases.
Mm-hmm. Yeah, it's interesting. I guess switching gears, thinking about restaurants and the types of cases we typically see. I mean, they run the gamut, right? So everyone is probably aware of the website accessibility cases and then the physical brick and mortar type cases. There are steps at the front entrance. We need a ramp. We need a lift type thing. One thing we've been seeing a lot lately are issues related to service animals or animals generally. So if you're a restaurant, and most restaurants have something like a no pets policy, right? And it's usually for a reason because it has to do with cleanliness or patron experience. You don't want dogs barking or things like that. But how do you deal with issues when a person comes in and says, this is a service animal or this is an emotional support animal and I need them with me? Like what's your take when you get those issues? How do you go about addressing them with clients?
I actually just am almost wrapping up an issue that the DOJ had brought against a client who was a restaurant. And there's a lot of dispute factual ones in that one as to what exactly happened. But a woman had complained because she came in with her dog, which she claimed was a service animal. And they said that she couldn't stay there. Apparently that was the allegation. But the thing is with a service animal under the ADA, first of all, it has to be a dog or a small horse. And I hope no one is bringing your small horse into a restaurant because that would be very, very crowded. But you can't really ask a lot of questions. You can ask, one, is this a service animal? And number two, what service does it provide? You can't ask if they're disabled, what disability they have. You can't ask for any sort of certification. And by the way, there is no such sort of certification. If someone says, I have a certification about this service animal, they have been duped somewhere, or they are trying to dupe you, because you can just order papers off of Amazon that says certified service animal. So anything to that effect is not worth the paper that it's written on. But you really are limited to those two questions. And if someone says, yep, it's a service animal, and, you have to see what it says for you. And then you're going to have to make that judgment call. Like, are you really going to call this customer out and say, I don't really think that is a service animal? And another thing people always ask, though, about, they do have to behave. There are parameters on the service animals when they're in a restaurant. They can't sit at the table. They have to sit on the floor. They have to be leashed, or otherwise under control. If somebody has a disability that they can't keep a hold of the leash, they can't bark. They can't, defecate, things like that in a restaurant. But if someone has a service animal, then you really can't bar them from bringing that animal in, as long as it's under control and sitting, on the floor.
Right. I mean, and that goes a lot to training, right? So if you're a front of the house person at a restaurant, knowing, okay, this person has an animal, immediately I can tell it's a cat.
Yeah.
Right. So it's
meowing.
It's not a service animal, right? Because ADA Title III doesn't provide any coverage for emotional support animals. So if you're thinking about, well, I'm an employer and I have to accommodate employees with disabilities, and some people have emotional support animals, this is different. When you're talking about a customer, a member of the public coming into a place of public accommodation, there's only protection for these service animals. So if you see it's not a dog or a miniature horse, then okay, this can't be a service animal. We do not have to allow it, even if they say it's a service animal, even if they say it's an emotional support animal. Any good advice as to, like, all right, we understand that the animal needs to behave and be under control, but say if the animal barks a couple of times or is on a leash, but it's like walking around the table. Any good advice on how to train employees on dealing with that situation in real time?
That was actually one of the things that we agreed to with the DOJ, is that we would have some training, but it was more of training as to how to recognize a service animal and not, how to correct its behavior. But I would say that, the front of the house employees do need to be aware of the parameters, and that, if an animal is being disruptive or barking, that you're going to need to go up and, tell the patron, that this can't happen. I mean, and it's up to you. Do you want to say one strike and you're out? Or do you want to be like, hey, if this happens again, like, we're going to have to ask you and the animal to leave? I think those are going to be what you want to have to make that decision as to how much of a leash do you let it go out on. But, and then what really your policy is going to be on that, and who's going to be the one to tell it. I would say it's probably best for the manager to do it. If it's, something like being disruptive and whatnot. People feel very, very strongly about their service animals. So it's a really good way to get in a disagreement with a patron if you're trying to disallow or remove the service animal. But at the end of the day, you have a business to run, and if the animal is doing things that are outside of the scope of the ADA and are disrupting your business, then you have the right to make sure that it is complying with the ADA.
Definitely a beast of an issue, and I'm glad you're dealing with it. I guess we have time for one more topic that we see come up a lot with restaurants and hospitality, and more so where you are in Nashville than where I am in New York. But accessible parking, right, and issues surrounding that. And I know, just generally speaking, a lot of times the issues come up because the parking lot might be a shared parking lot, and the case may be only against the business owner, the restaurant or whatever, saying you don't have enough accessible parking. There's something wrong with the way that the parking's laid out. You don't have an accessible route from the parking lot to the front door of the entrance and things like that. And as a tenant, you find yourself in a dispute with the landlord as to whose responsibility this is, what are the obligations, et cetera. So any advice to clients on how to be proactive to ensure that they're not violating the ADA as it relates to accessible parking issues?
Well, two big things. You need to look at your lease and see who is responsible for the parking, and not just the parking, but like you said, the accessible routes, the sidewalks, the entrances, everything, where someone needs to be, on a path of travel. See who's responsible for that. And if it's you, then you want to go out there and be sure that it is meeting the standards of the ADA. And even if it's not, and it's someone else, I still would look and see if it's meeting the standards. And if it's not, you want to let whoever is responsible, if it's your landlord, know that this isn't up to snuff and that they should, probably do it because, get it remediated. They don't want to be on the hook. And then check and see if you have indemnification language, because that's what happens all the time is the wrong party gets sued, or there are multiple issues I have a case right now, and there's issues in the parking lot, and there's issues, in the accessible route, and there's alleged issues in the restaurant. And my client is only responsible for the accessible route and the issues in the restaurant, but not the parking. And the only person who was actually sued was a trust who owns the parking lot, and they have a lease with someone else for the parking lot. And then there's us, and it's very complicated. But actually that does bring up one other little issue with the restaurant. And the issue that was allegedly the issue on the inside of this restaurant was the bar. And the bar, they alleged, was lacked accessible seating, which is completely false because I have photographs of the bar. There is a lowered portion after the 2010 regs require that any building that has been constructed or altered after March 15th, 2012 has to have a portion of the bar that is lowered down to believe it's 36 inches high and 36 inches long. And that's something that gets missed a lot in construction plans. And so that's just something to look out for if anybody has a bar. And it's something I always notice when I am at a bar because it's definitely something that's noticeable. And you're like, I know this building was built, a year ago. It definitely applies. So you see that gets missed. But since it's easy to notice, it's easy for a plaintiff to walk in and see it and say, hey, the seating is wrong. And Title III it's a strict liability statute. So they don't have to really prove too much. You can't be like, oh, well, it was in the plans and the builder didn't build it or anything like that. That's not going to be a defense.
Right. Definitely interesting. And I mean, going back to the parking thing too, like here in New York, we don't really see too many claims that include parking. A lot of times in the city, there is no parking, but there's always landlord-tenant issues, right? There's a lot of the times both defendants end up being the landlord and tenant, and you're pointing fingers who's responsible for what. So knowing the lease before you sign a lease, knowing how is this going to be addressed if and when it happens, and having represented both sides, the landlords always want to take the position, listen, this is their business, right? It's their responsibility to make it accessible for their customers. And then the tenant's like, well, I inherited this like this. There were steps at the front entrance. I'm not allowed to just start modifying the front entrance or facade of the building. It's not my building. How am I supposed to do that, right? So there needs to be some level of understanding and cooperation going into it. And even if the deal is already done, knowing whose obligations are whose and maybe trying to get ahead of it. So the issues never end.
They don't. Well, I think that is about all the time we have today. So I think we'll wrap up. But it's been so fun chatting with you, Joe, about all the Title III fun in restaurants. And I hope everyone has enjoyed our little chat. And if you have more questions, stay tuned and we can get you all more information. Thanks, y'all.
Yeah, thank you, Jen. Great time.
Thank you for joining us on We Get Work. Please tune in to our next program where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.